ज्ञानदायिनी हंसवाहिनी ज्ञानदायिनी जो विधात्री यो विधात्री जो विधात्री यो विधात्री ज्योति का संतान दे ज्योति का संतान दे शौर दे वरदान दे ज्योति का संतान दे शौर दे वरदान दे हंसवाहिनी ज्ञानदायिनी हंसवाहिनी ज्ञानदायिनी विश्व के अंधेर घट में गिरन जाए इस सफर में विश्व के अंधेर घट में गिरन जाए इस सफर में दीपों का हार दे शार दे वरदान दे दीपों का हार दे शार दे वरदान दे हंसवाहिनी ज्ञानदायिनी ज्ञान का भंडार दे ज्ञान का भंडार दे शार दे वरदान दे हंसवाहिनी ज्ञानदायिनी हंसवाहिनी ज्ञानदायिनी.
Very good. Very good.
ಈಗ ಪ್ರಾಸ್ತಾವಿಕ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ಕೆ.ಎಸ್. ಪುಟ್ಟಸ್ವಾಮಿ ಅವರಿಂದ.
First, I congratulate Kumari Aditi, which I had failed to do last time. I wanted to meet her, but I wrote a letter which was acknowledged by his father. Honorable Dr. Justice M. Ramajoyce, Mr. Soli Sorabjee, Honorable Mr. Vijay Malimadat, Honorable V.S. Malimat, Honorable S. Rajendra Babu, Srimati Usha Shankar, Principal Accountant General of Karnataka, Mr. A. Ramaswamy, Chairman of the Karnataka Appellate Tribunal, and Mr. T. Venkataswamy, my good friend, and Mr. S. Ramaswamy, and Kumari Vijaya's father, and friends. I, on my own behalf, and on behalf of the Gokhale Institute of Public Affairs and the Indian Liberal Group Bengaluru chapter, extend a hearty welcome to the two legal luminaries, jurists and acknowledged experts on constitutional law of our country, occupying the dais, and all those persons in this hall and outside. Dr. Justice Ramajoyce and Mr. Soli Sorabjee had both participated in a lecture program in remembrance of Mr. Minu Masani on 29/12/2005, in which lecture also I had the privilege to introduce them. Both these are household names to the intellectuals of this country in general and the members of the legal fraternity in particular, and therefore require no detailed introduction. But as a matter of courtesy, I propose to say a few words on both of them, omitting details. Dr. Ramajoy is born on 27 July 1931 in Araga village of Tirthalli Taluk of Shivamogga district. On completing his BS and BL degrees from Central College, Bangalore and Government Law Colleges, Bangalore respectively, started his legal practice in 1959 in Karnataka High Court with a brief apprenticeship in the chambers of late S.K. Venkatarangaigar, who was then one of the leading lawyers of Bangalore. With his erudition and clarity in presentation and specializing in service law and constitutional law, he soon became one of the leading lawyers in those branches. When he was practicing as a lawyer, he authored his first book, Services Under the State, on the persuasion of the then Chief Justice Mr. Narayan Pai, which has run into several editions and is still a reference book for the members of the bar and the bench in our country. He was appointed a judge of the High Court from 28/11/1977 and subsequently became the Chief Justice of Punjab and Haryana High Court, which he resigned as his just claim for elevation to the Supreme Court was unjustly denied. He has continued his research work and has authored another 17 books, one of them being Legal and Constitutional History of India in 2 volumes. The publication has been sponsored by the National Book Trust of India Book Trust, and the book has been prescribed as a textbook for law degree courses by the Bar Council of India. Justice K. Ramaswamy of the Supreme Court, in his foreword to one of his books, has even referred to the opinion of Dr. Ramajoy in the famous A.S. Narayan Dikshitulu and others versus State of AP and others, 1996, 9 SSC 548, which upheld the validity of abolition of hereditary archaks and pujaris in the famous TDT temple and all other temples of AP under the AP Charitable and Hindu Religious Institutions Endowment Act of 1987. He has been awarded an honorary doctorate by the Kuvempu University and Naresh Chandra Sen Gupta Gold Medal by the Asiatic Society, a prestigious society situated in Calcutta, for outstanding contribution for the study of society and law. For a period he was Governor of Bihar and Jharkhand. He has been recently elected unopposed to the Parliament of, that is Rajya Sabha, House of Elders. Mr. Soli Sorabjee completed his legal education from the Bombay Law College in 1952 with a distinction, winning the Kinloch Forbes Gold Medal in Roman Law and Jurisprudence. In the Law College, he was a student of Mr. Nani Palkawala, who was one of the greatest lawyers of his times and a professor of the Bombay Law College. Mr. Sorabjee then joined the chambers of Sir Jamshedji Kanga, who was then the leader of the Bombay High Court Bar, in which Mr. Nani Palkawala and few others of outstanding eminence were associated. With his erudition and clarity, he has soon made his mark in the profession and shifted to New Delhi to practice before the Supreme Court of India. He has served as Additional Solicitor General, Solicitor General of India, then as Attorney General of India, twice from 1989 to 1990 and 1998 to 2004 with great distinction. In March 2002, he was awarded Padma Vibhushan, second highest civilian award. He has authored several books on law and constitution. Even with very busy schedule in the profession, he finds time to contribute articles to legal journals and a national daily. When Mr. Soli Sorabjee was first appointed as the Attorney General of India, Mr. Nani Palkhiwala, by his letter dated 11th December 1989, said thus, "My dearest Soli, I meant to write to you to congratulate you on your appointment as the Attorney General. But after reading your public statement, I would like to congratulate India on having you as the highest law officer of the government. What you have said about the Attorney General's office, the guardian of public interest and the promoter of human rights, is so true and so little understood. The greatest glory of the Attorney General is not to win cases for the government, but to ensure that justice is done to the people. In the US, the motto of the Justice Department, carved into the rotunda of the Attorney General's office, is the United States wins its case whenever justice is done to one of its citizens in the courts. You will mark a new stage in the evolution of public law in India. May you have a long and fulfilling term in which to effect the luminous change. YD page 443, Nani Palkiwala, A Life by Mr. M.V. Kamath. A better tribute cannot be paid by any other person. Mr. Sorabjee is presently the Vice President of the Commonwealth Lawyers Association and member of the UN Subcommission on Human Rights. Only yesterday, Mr. Sorabjee delivered a lecture on essence of democracy under the joint auspices of Nani Palkiwala Memorial Trust, Mumbai, National Law School of Mumbai, Bengaluru, at Yuvanika, which we had the privilege to attend, along with Vijay Malimat and others also. At Yuvanika, Mr. Sorabjee and Dr. Ramajoyce have contributed two thought-provoking articles on the lessons to be learned from the working of our Constitution and need for review of the Constitution to 50 years of Indian Parliament, published by the Lok Sabha Secretariat, New Delhi, 2002. I am furnishing their copies, my welcome speech on 29/12/2005 and the detailed biodata of Dr. Joyce to GIPA office for the information of those who are interested to make their copies and study them. With these few words, I request Dr. Ramajoyce to preside over the function and conduct the proceedings. Before concluding, I wish every one of you a happy and prosperous Deepavali. I thank all of you for your presence. Thank you, sir. Huh? Very sorry, sir, by the time. Right. Thank you, sir. Mr. Joyce will conduct the proceedings.
Justice Ramajoyce, Justice Puttaswamy, Justice Ravindran. It's a very, very unexpected, delightful surprise. Former Chief Justice of India, Justice Ravindra Babu, Justice Malimat, former Chief Justice of Kerala, Justice Malimat, other distinguished dignitaries, ladies and gentlemen. I am very thankful to the Indian Liberal Group Bangalore chapter and the Gokhale Institute of Public Affairs to have given me the opportunity of talking on a subject which I am sure has been a concern to all of us who have noticed the developments which have taken place in the course of the life of our nation and the development of the Constitution. Now, friends, a constitution is not like any statute. It's not the Income Tax Act or the Excise Act, which you can amend 10 times over and go from 25A to 25Z. Constitution is the basic law of the country. It really reflects the character and the aims and aspirations of the people. In fact, I think it's right to call it's the soul of the nation. It depends. If a constitution is secular and democratic, then certain forms of government, certain principles flow therefrom. If the constitution is theocratic, as it may well be in other cases, then different considerations arise and different principles emerge from that constitution. Now, our constitution was deliberated for over 3 years, about 2 years and 11 months. Started on the 9th of November 1946, a very cool wintry day, and the Muslim League had boycotted, and it wasn't very propitious beginning. But it was debated, discussed, every clause, and it was done by people who were well enlightened. not by partisan politicians wanting to serve their private ends. And it is really actually one of my favorite books, you may think it's a little absurd, is reading the Constituent Assembly debates, especially the preamble, fundamental rights, directive principles and other things. And one will be surprised to see the foresight of the founding fathers, the wisdom, the experience how they brought to it. And at the end of it, we did give unto ourselves a constitution. Now, despite all labors and despite every erudition, no constitution can be perfect. No constitution can be permanent. Because a constitution has to respond to the evolving needs and problems which surface in the life of a nation. In fact, Jefferson, one of the great architects of the American Constitution, put it very well. And he says, I am not an advocate for frequent and untried changes in laws and constitution, but I know that the laws and institutions must go hand in hand with the progress of human mind. As new discoveries are made, new truths discovered, and manners and opinions change with change of circumstances, institutions must advance also and keep pace with the times. Our Prime Minister, Pandit Nehru, expressed himself quite forthrightly. He said, a constitution which is unchanging and static, does not matter how good it is, how perfect it is a constitution that has passed its use. It is in its old age already and gradually approaching its death. So therefore, there is a provision for amendments in every constitution. But the caveat is that it is a solemn document. A constitution is not a plaything of the politicians. Therefore, frequent amendments to the constitutions, I think, are not really warranted. In fact, it shows a lack of respect for the constitution. Now, we have worked the constitution for 60 years. Review of the constitution. One of the things, friends, which has really surprised me is that till the constitution was hardly 1 year old, and we had passed it with fundamental rights and various other things, and there we had the Constitution First Amendment Act, which inserted Article 31B and the 9th Schedule. And what did it say? Any act placed in the 9th Schedule cannot be challenged on the ground of violation of any fundamental right, not merely property, any fundamental right. So put it in the 9th Schedule, complete immunity. Because one must realize what happened. Agrarian legislation was struck down by the Patna High Court. Patna High Court did it under Article 14. Allahabad High Court did it on some other article. So Panditji was livid. He says, these lawyers had assured me that these matters won't be interfered by the court. In fact, he was very angry. And I think he was referring to Munshi. He said, these laws have purloined the constitution. So then he went to Parliament and said, look, these are just 10 or 11 pieces of legislation. That was also our pledge to the people. Just like fundamental rights are pledged to the people, so a pledge to the people to abolish zamindari, land estates. So let's have these acts in the 9th Schedule. Now at that time, 51 Panditji, other people, so they said very well. So 13 acts came in the 9th Schedule, maybe 11 or 13, I'm not too sure. But thereafter, the appetite grew. And then you had all kinds of acts. MRTP Act, Insurance Act, some provision of Railways Act, Foreign Exchange Regulation Act. And today, if you see, it is now after the Keshwanand Bharati is less, there were about 298 acts in the 9th Schedule. I mean, that was something, and as someone has called this a constitutional breaking amendment. An act in violation of fundamental rights, you put it there. And what is worse, in some cases where a High Court has struck down, or even a Supreme Court has struck down an act on the ground that it violated fundamental rights, you put it there and retrospectively the invalidity is gone. So to my mind, friends, and that is what we suggested in the National Commission for Review of the Constitution, of which I was a member with Chief Justice Venkatachala as the chairman, that either you abolish 31B or restrict 31B, confine it to laws which in pith and substance deal with agrarian and land reform. 31B should be for that purpose and should not be there. Did you notice once I read in the papers, I think Basantara Raja or someone said about Gujar agitation, they made a mistake. You should put this act in the 9th schedule. But 9th schedule is not like a residuary basket. I mean, you can't just play with the fundamental rights of the people. So I think it's very necessary that this 31B, if it is to be retained, its ambit and operation must be confined to laws which deal with agrarian and land reforms. Secondly, we found in 1975, rather 76, that Article 359 says that during emergency, all fundamental rights can be suspended. So, when we went to court, we were told, sorry, fundamental rights suspended means Article 21 suspended. Article 21 suspended means even if it's a mala fide order of detention, sorry, you can't challenge it. Just couldn't believe it. Just couldn't believe it. And the persons, two judges on whom we had put implicit faith, he said, don't bother about them, they'll be with us. They can never accept such a proposition. They took another view, and the only one, the dissenting judge, was the great Justice H.R. Khanna. And let me tell you, Justice Subara was passing through Bombay. I think his son was living in Bombay, he was there. He came home, and I told him this is a judgment. He just shook his head, no, can't be. Mala fide order can't be challenged. That's what they were. No, can't be. Yes, but it is so. And he was just shocked. He just couldn't believe it. Then I had to calm it down before he could have his dinner. Otherwise, he was so shocked he didn't want to even have anything. Now, the reason is, after that, realizing the consequence, Constitution was amended and said Articles 20 and 21 cannot be suspended during any emergency. 20 is retrospective, I think, operation of criminal laws, and protection against other criminal laws there, and 21. But we feel, and I do feel, but even during emergency, why should Article 17 not be suspended? Should be suspended? Practice of untouchability is abolished. Why should Article 25 be suspended? Freedom of religion? What connection has it got with emergency? I can understand the other rights under 19, because the war, some of the things, free movement, property, business, everything else. But take Beggar, 23, 24. So if you really think about it, these are also articles which need not be suspended during emergency because their exercise does not in any way impede the war effort or whatever the effort you are making to quell internal disturbance. And of course, the one article which should be non-suspendable is Article 32. If you suspend Article 32, whether you suspend others or not, then I think it's not much of a meaning. So that's one matter which I have thought about, and that is where I think if we think about it, this amendment should be made. It's a good thing. 2021 will not stand suspended, but please add these articles also. 17, practice of untouchability is abolished. So during emergency you can practice untouchability. But other things, very well, I won't dilate on that. The other experience we found was frequent imposition of Article 350, even invocation of 356, and imposition of President's rule. Now, the whole idea was the President's rule will be imposed when there is complete breakdown of constitutional machinery. This is an impasse. As Dr. Ambedkar said, you don't have a surgical operation for a cold or a catarrh. But as we saw, this article was misused, and it has a tremendous fascination for whichever party is in power. In fact, I remember I had to really become a little unpopular. I don't think I'm discussing any secrets. When the Vajpayee government was tempted and was asked to impose President's rule in Tamil Nadu. Why? Because Madam Jayalalitha was forcing, Jayalalitha से मेरे को बहुत तंग करता है, रोज फोन करती है, मेरे को अटल जी एक काम करो, उसको बोलो कि अटल जनरल मना करता है, मेरे को I can easily take Jayalalitha on my shoulder. So he looked, he has a good sense of humor, he said, are you sure? So 356, and you know it's an assault on the federal structure of our country, federal fabric. Because it was just misused to get a government which was not acting according to your wishes. They wanted to be dismissed, and the people who had elected an assembly, their rights are also taken away. Then, of course, has come the great judgment of the Supreme Court in Bomaya's case, which has explained what are the circumstances where they've endorsed the Sarkaria Commission recommendations and also said judicial review would be available. Now, I think why not, since the judgment is there, no one has challenged this, amend 356, lay down the parameters under which only it can be invoked. The other one, sir, I think is, we are a democracy. But I think the worst danger to democracy is this evil of defection. Defection is the worst form of political corruption or political immorality. We wanted to deal with it. Very well. So you've got the 10th schedule. Very well conceived. But the 10th schedule, unfortunately, let me tell you my experience, is not working satisfactorily at all. Why? Because the speakers, and my experience is speakers, especially from the northeastern states, they just don't have a correct conception of the role and responsibility of the speaker. They think they've been appointed by the chief minister, so their loyalty lies to the chief minister. And I had a very unpleasant experience. There was a conference in my chambers. I said, yes, who's this, so and so. No, who's this? He's the speaker. What? Like, what's he doing in my chambers? No, sir, I'm on your side. Then Praveen Parak was the advocate on records. I told him in Gujarati, can you please ask him to leave the chambers. He's not even Gujarati. And the speaker was very angry. He complained to the chief minister, Sorabjee, your counsel, he didn't realize I was supporting you, I was with you, and he asked me to leave the chamber. Now, with the result, I've noticed this very often. Disqualification petitions kept pending. Therefore, please give this power. Power of disqualification is a very awesome power. You disqualify MP, of course, it means a lot. Give it to a multi-member body. I had suggested election commission, which can take an objective and an impartial view of the matter. It has not worked at all. It will never work so long as the mindset of the speakers is that they owe their loyalty to the chief minister who has appointed them speaker. Talking of democracy, look at the other thing. We are so naturally upset, criminals getting into parliament and state legislatures. And it's a fact. If you take statistics and see so many history sheeters, look at it, they have a very colorful criminal record. But then why not amend the constitution and make it account for disqualification? Namely, that if a person, after charges have been framed by a court and is facing a criminal trial, he will not be eligible to stand for election. And to stand for election is not a fundamental right. His whole, thing doesn't depend on him. He did not serve the people. Let his patriotic instincts be at a little in abeyance till he is cleared. But otherwise, you'll never have it. If you say only after conviction, we all know, criminal trials are prolonged, number of adjournments, and I must say, my tribe also is very good in securing adjournments. Sometimes the law gets dysentery. Next occasion, the client gets diarrhea. On the third occasion, something else happens. And judges also are a little kind, not very strict as they should be in such matters. And then it goes on. So please have this. We don't want such people. Do you want criminals to make laws for us and our children and grandchildren? This is the one thing which I think is very necessary, if coupled with the defection matter which I have spoken about, and if we want our democracy to be a healthy democracy. The other thing I'd like to say is, I don't know, this is problematic. Should there not be some qualifications for the elected candidates? Property qualification out of the question in a country like India. Educational qualification also I don't know. BCom, BSc, BA, LLB. But some minimum literary qualification? Because I know there are some members who can't read. So if they can't read, how are you going to participate when a particular law is being discussed? Whether it should be enacted or not. It's a problem which is not very easy, but I think it is something to which we should apply our mind. Minimum literary qualification. Otherwise, we have people who just don't know, and they can't know, they don't read it. Whoever tells them to do this, okay, we do that. The other thing which I feel is, when we are talking about our Constitution, is the fundamental rights which we have. We framed our Constitution in 1950, 49-50. We have a good area of fundamental rights. But if you see the later constitutions, and if you see the International Covenant for Civil and Political Rights, 1966, which we have ratified, there are many rights which are not included in our Constitution. Our Supreme Court has, by judicial creativity, reduced these rights. Do you know, people are not aware, many of them, you don't find freedom of the press in our Constitution. Where do you find it? It's not there in the Constitution. It was deduced from freedom of speech and expression. That's implicit in freedom of speech and expression. That's Guru Ramesh Thapa. And that, of course, gone on. Thereafter, we have reduced the right to privacy, right to travel abroad from Article 21. Of course, Article 21 is a very good residuary thing, where many things we reduce from the right to education, right to privacy, right to travel abroad, and also freedom from torture, no cruel or unusual punishment. Now, if these rights have been judicially deduced, and no one can have any objection to enlargement of fundamental rights, the previous amendments were diluting fundamental rights, why not incorporate them expressly? And these are in keeping with international thinking, international jurisprudence. Okay, these are the rights also in other countries and other constitutions. Speaking of enlargement of rights, you know what our Supreme Court has done? I mean, that's great. I must say remarkable. Directive principles not enforceable. You have it. But some directive principles have been incorporated in the fundamental right. And I think the best example, sir, is life. In Article 21 does not mean mere physical existence. Right to life means right to live with human dignity. And from that right to live with human dignity, we have got a right to medical care, a right for wages in keeping with dignity, pollution-free air, water, pollution-free water, and the whole environmental jurisprudence has been built up on the expression life and how. So we have in effect made certain directive principles justiciable by incorporating them in fundamental rights. But then do it clearly. You see, the objection was, no, directive principles, very difficult to make them justiciable, very difficult to make them enforceable. The Constitution of South Africa, I'm saying South Africa, which also underwent a colonial regime and apartheid, I'm not talking of America, Canada, other places, has some of these rights in their Bill of Rights. There were no problems. Of course, the judges say it must be within the capacity, economic capacity of the state. And that's a very good example. So we can actually enlarge the rights of our people. Don't depend on judicial interpretation. Some other judge may think it is all nonsense, you can't do this. Judges have different views. How do you read things into it? I'll only read the text. Please don't. Judicial minds may differ, interpretation may differ. Make these rights which are really meaningful to the majority of our people. To them it matters. Health, sanitation, basic necessities, basic protection against other treatment which they receive. And therefore the South African Constitution is an answer to the skeptics who say you cannot make directive principles which are socio-economic rights justiciable. Yes, not all of them. But some of them which enhance the quality of life, which makes the life of a human being a life with dignity. And that I think we should do, and we should think about that very seriously. I think that's about all now. Yes. You can't do anything but lawyers. Can you do anything but lawyers? Constitution, the first thing is, can you say you don't charge more than certain fees? You don't take more than 15 matters on a particular day? But there should be something, because lawyers, our profession is essentially a service-oriented profession. I'm not saying you don't charge. Lawyers don't live on love and fresh air. They have to charge. But the main idea is not And that's what I feel very upset when some juniors think within 2 or 3 years they'll make a mini fortune. There's nothing wrong in making money. If you want to make a fortune, do it, if it would be honest means. But then go in real estate, go in import-export business. With that mindset, don't come in the profession. And that is what is happening now. Today, the legal services of so-called top lawyers has become so impossible for ordinary man, it's inaccessible. There's no access to them. I think there should be some base found, may not necessarily by amendment of the Constitution, to make cheap, expeditious legal services within the reach of the common man. Because after all, it is for the common man, for the common person, that laws exist, that the Constitution exists, and we must not forget the consumer of justice. Well, friends, I think, yes, of course. I forgot. The one problem that has surfaced is about judicial accountability, appointment of judges, and removal of judges. When the provision for impeachments was there, I don't think any of our founding fathers would have thought, we'll keep it. But no one would have thought it will never be invoked or used. Well, our experience has been that this impeachment process is cumbersome, is very tardy, and gets politicized. And you had actual instance in the case of Justice Ramaswamy. The whole motion failed because the Congress abstained. So it got politicized. Now the fact of the matter is that we have a peculiar situation. Before the judgment, when the collegium came in, the executive had the exclusive right of appointment. And we said, no, that can't be. Then they have Sarkari judges, this, that, and the rest of it, they can't have it. So we went full circle. So now the Supreme Court has the right to appoint judges. Now, frankly, I say so with responsibility, very well conceived. In fact, I am the guilty person because I argued that matter of the collegium before 7-judge bench. But in practice, it hasn't worked satisfactorily. We must face the fact, especially in certain high courts I received report, it's a trade-off. Chief Minister, Chief Justice. It is not working satisfactorily, so let's face it. And therefore, I think the need for a commission, national commission for appointment of judges has become imperative. Of course, the whole question is the composition of that commission. Who will be the composition? One suggestion is there should be 1, 2, 3, someone from the executive, because it can't be the executive has no participation at all in the appointment of judges. Formally, that's the sole thing. It can't be sole. Someone from there. Then some eminent jurists whom the President, in consultation with the Chief Justice, may appoint. But these are matters of detail. But I am very clear that in that body, whatever its composition, the judiciary must have an edge. Because the judges know who the lawyers are. Judges know who they are, how they practice, how they work. But it cannot be the exclusive sole privilege. You won't find in any country in the world, please correct me, where the judges and judges alone have the right to appoint judges to the High Court and Supreme Court. So this has to be balanced. We must have a commission. The composition of the commission also must be such that it inspires confidence, and the judiciary must have an edge in that. There's no question about it. Still worse, what happens when you have cases of so-called corruption amongst other judges? What do? Has your impeachment process worked? So therefore, National Judicial Council, as in Canada, there also there's no question of anyone. That must be merely peers, only judges. No ministry, anyone from the executive, anyone. So that also can go into questions of what they call deviations, what they call deviant behavior, what we call misconduct. But this is not a question to which this is not a problem to which an easy answer, but this is something which has been agitating me, has been agitating many others. Because if you are a National Judicial Council to discipline judges, please remember that they are under the slogan of accountability, don't compromise judicial independence. An honest judge, a fine judge, can also suffer if there are certain groups who don't like him because of his attitude or because of his judgments. So these are things we have to be very careful about, and I certainly totally disagree with some of the colleagues who say in the National Judicial Council you should have members of the opposition and some politicians and others. Out of the question. In a matter of removal, the judges will be judged by their peers. And I think these are matters which we must think about. So I started with 31B, and I'm ending with this because this is at the end something which is agitating us. Friends, these questions must be considered objectively, impartially. Personalities do not matter. Whether Mr. A today is being questioned or B questioned is not the question. We have to think of the institution. Because let me tell you, and this is my firm belief, that despite the number of drawbacks and deficiencies and the shortcomings of the judiciary, it is the one institution which has really kept the state and preserved it, and preserved the fundamental rights of the people. And what I feel very upset is that because of some human nature being what it is, some bad eggs and something, it's a very bad reflection, inference to think that corruption is rampant in judiciary. I've practiced in different courts, and it's my firm, honest belief that the majority of the judges, the vast majority of judges are hardworking, honest and sincere, and it's very unfair to them to tar them with the same brush because of some couple of rotten eggs there. And we must realize that, because ultimately, if we didn't have a judiciary, we would have a police state. If we didn't have a judiciary, you would have your fundamental rights would be completely merely parchment promises. If we didn't have a judiciary, we enforce the rule of law, which means for any executive action which is prejudicial, you require legal authority. Mere diktat of the police commissioner or the circular of some minister won't do. This is what the judiciary has done, and we owe it to the judiciary to strengthen it and to engage not in the acrimonious debate, but to see how these problems can be solved in a spirit of collaboration, in a spirit of cooperation, the idea being only preserve this institution, enhance its prestige, make it more effective in enforcing the rights of the people and making their life worth living. Thank you.
Mr. Sorabjee will take questions for about 15 minutes. Those who want to ask questions will please come to the dais, introduce themselves and ask the questions. No, after. It's for questions.
Okay. Yeah, sure. There is one matter I had noted, but I didn't speak about it. I saw Justice Ravindran here and I've argued that matter before him. So I shouldn't refer to that article of the Constitution at all. Yes?
I can go out and you can come.
No. That's not. So what's the matter? Right.
Good evening, sir. My name is Abhay Bhargav. Good evening. My name is Abhay Bhargav. I have a question. No, I'm an information security consultant. My question is that, I don't think it's totally related to the Constitution, but it has to do with the multiple political parties we have in India. Do you think that's holding us back in any way? Because we have splintered groups, we have hung parliaments. These are things which we have to deal with, and the people's mandate is generally not enforced. It's not adhered to by the states or at the national level. So.
That's a good question. That's a question of electoral reform. So thereby they want... So groups and parties which haven't done well or haven't secured a certain percentage in the elections, the room is to sort of beat them out. But mind you, again, the right, this is a very important right, and one must think twice before you really impose any such ban. And it must be in respect of groups of others who have got no showing at all in the election. And the unfortunate part is some of these people really become kingmakers. In a case of a division, the people who would not be otherwise sought after, they are there. They know, they extract their own price. But this is a complicated question. The question you raised is very important, but it deals with, it requires an amendment of the election laws, and that will have to be looked at in depth.
Oh, just one more question, if you
sure.
don't you feel that we need to have a prime ministerial or a chief ministerial candidate announced before the election, a clear candidate? Because we have a lot of tussles after the election results are out. So,
That's a question of political wisdom. In a case it's announced before, it's better. So he also knows, otherwise thereafter there's a lot of bargaining taking place. But that's for the parties to decide really. Personally, I feel it's much better if you announce it.
Thank you very much. Thanks.
Have you got a mic going around? To give the mic there instead of coming up here?
Good evening, everyone. My name is Anand Tirtha. I'm a software engineer. Also, I'm studying a political science student. So, one question is, in the Indian government system, we have a lot of holidays and strikes and begging. And also, we have summer holidays for judges, winter holidays. Don't you think this should be abolished because the cases are running for years? So these holidays were given during British time to go to London and visit their families. But still we are following these things. Don't you think?
During British time, they didn't have Ambedkar Jayanti, Mahavir Jayanti, Parsi New Year, other thing. Don't say British times. These holidays, some of them as a result of the pressure, some people, they feel that there must be holidays. I do agree. We have far too many holidays. If I were a sort of benevolent dictator, it's a contradiction in terms, no one can be benevolent dictator, I had only 3 holidays. Independence Day, Republic Day and Gandhi Jayanti. Rest may be optional. But please, one thing, when you say judges going on summer vacation, do you know how judges work for 4.5 hours in Supreme Court or 5 hours? Do you know the work they put in? Do you know the myths that the judges only work for 4.5 hours on Monday to Friday? Their Saturdays, Sundays are really not spent with their family and with their friends. They're reading the SLPs and the transfer petitions and the writ petitions which come up. And then they have to prepare judgments, they have to write judgments. So don't have that impression that they wanted to go to London and anything like that. They are one of the most hard-pressed functionaries. And you don't know the amount of litigation that has come up to the Supreme Court. And of course, sometimes it happens that some judgments cannot be given within a short time. There's discussion, there is debate, there may be a difference. But don't get the impression that these holidays are for the benefit of the judges. Or they used to go to London, the English judges, and refresh themselves. No. They require this least thing. Otherwise, I don't think they'll be able to function very effectively. They'll be mentally, let's say, too much work. In a way, the Supreme Court is to be blamed. They entertain too many SLPs which should be dismissed as a threshold. But please don't use that against me.
Thank you, sir.
I am a retired bank official. Sir, my question is about a particular word, secular. I do not know. In between the lines have also been interpreted, and I think it is in between the letters it is going to be interpreted. What is your opinion about the ambit of the secular in the Constitution?
Okay, thanks. First of all, to my mind, secularism was implicit in the Constitution because it's a necessary corollary of the principle of equality. Now, secularism, in short, means this. Secular state is not anti-God, nor pro-God. If a person wants to practice his religion, there's full freedom of religion, he can do this, the state doesn't interfere. Provided, of course, that religion, the practices are not opposed to public order, morality, or health. At the same time, secularism means that the state does not give patronage, doesn't financially assist any religion. So there is strict neutrality between religions. That is the essence of secularism. Secularism is not anti-God, it's not anti-religion. It is, the whole idea is, state won't interfere in matters of conscience. Whatever faith you want to practice, whatever religion you want to believe in, please do it, so long as the outward acts do not contravene any public order or that sort of a situation. At the same time, the state will not promote any religion directly or indirectly. In practice, sometimes this is not kept. Sometimes subsidies are given. For example, Hajj subsidies has raised a very important question. But that's a different matter. But that is the essence of secularism. And even if secular was not stated in the constitution, it was an inevitable corollary from the principle of equality, which also would mean treat every religion equally.
I am Arvind, Bangalorean.
What do you do?
I am Arvind Kumar, Bangalorean.
You know, I'm so glad not a single law has come up. I'm very glad.
Sir,
Yeah.
every political party during election they will raise a Swiss bank account. Our national interest, can the judiciary tackle it? And corruption is so rampant and vested interests are only playing. Is there any solution in the judiciary?
But it really is in the hands of the electorate. Why do you vote for a person who has a well-reserved reputation for corruption? Why do you vote for a person who know is not honest because of his caste, because of his this, or because you really don't take corruption seriously? Maybe when he was the minister, one might have been the beneficiary of his corrupt acts. So this is not the judiciary can do it only within limited experience. They are not an ombudsman, they are not here to clean up the entire administration. Of course, if certain corruption has influenced certain corrupt motives or malafide motives, has actuated or vitiated a certain decision, they'll certainly strike down. But it is for you, the electorate. Don't elect such people. Understand? Next time when you exercise your vote, please remember that. Because if you vote them, you are actually in a way promoting corruption. No, that's a very wrong thing. If you say that, that's a very dangerous thing for democracy. They are not there. Maybe major, but there are some who are very good, patriotic people who have the interests of the country at heart. So don't jump to conclusions. Of course there is corruption, we all know. But then be able to tackle with it ourselves in our daily lives when it comes to it. Don't acquiesce in it. Abhi kya kare, to it's inevitable, corruption to hona chahiye, can't be helped. No, that's a wrong mentality. Fight it, resist it, and let the person know that you will not every time give in to his illegal, corrupt demands.
Hello, I'm Suri Prakash.
Identify yourself. What do you do?
I retired as a banker. Sir, I have a small question here as a corollary to the particular thing about the elected representatives. As you are aware, generally not more than 40% is the people who cast their votes. When out of 40%, if a person gets about 20-25%, he is the representative of 25% of that constituency. Now my question, sir, or my suggestion is, as we are talking about fundamental rights, why a duty should not be imposed in the constitution, a suggestion, so that every person who is to exercise this thing, he has to exercise his vote, and he should not enjoy that as a particular holiday or something, or he says, no, whomsoever I elect, it doesn't matter. He should not come to that decision. Let him not exercise, but he should be present on the day of election and should cast his vote instead of enjoying elsewhere. That's what
I entirely agree with you. I think it is a moral obligation of every voter, everyone who has to exercise his franchise. And I was never more angry than with some people in Bombay who didn't vote at the last Lok Sabha elections because there were 3 holidays, so went off for a weekend to Khandala or some other place. I'm ashamed of them. And these are the people who had cocktail parties and others say, oh, what is this? The administration is not good. Why don't you exercise your vote seriously? But there will be a problem to make it a mandatory duty. In Cyprus, in some states, it was made a moral duty, breach of which was visited with some sanctions, but then there are some problems. One court struck it down, others had it. So it must be really a moral obligation. If your friends, you have friends, if they don't go to vote, get them by the scruff of the collar and say, come along, go and vote. And you are right. This sort of attitude, because Mr. Palkhiwala had one thing, which I said yesterday. He said the greatest danger to democracy is voter apathy. is the indifference of the voters. And to make democracy successful, you require an active citizenry which realizes the value of the franchise, of the little mark he'll make on the little piece of paper in the little booth, as Churchill said. But that you got to motivate them. I don't think it can be done by law with penal consequences.
I am Nagraj, a retired banker. Can there be a negative vote? At least one positive and one negative vote. At least if the person who is supposed to be a criminal, he can have a multiple total negative votes, which is more than positive votes.
Yes, you're right. Late Krishnakant was a great proponent of that. A negative vote, I reject all that thing, but that has not yet been incorporated.
Good evening, sir.
Good evening.
I am Ramakrishna Prasad, engineer from ISRO. I feel happy to talk in front of you great people. Okay, my question is, because public interest litigation, can it be filed for the unearthed money in the Swiss banks and other banks? I heard so much money is available, which can means eradicate our poverty. Can anything can be judiciary can do to unearth that money? So much was talked during the election times regarding that money, and nobody is doing it. At least judiciary, can it help and bring up that money? That's what my question.
But the real thing is, the judiciary can or cannot do it, is entertaining a petition. But the main work is to be done by the government. It's the government which must take the initiative.
Sir, can
and with the Swiss, public interest litigation is not a cure for every ill. Please remember that. PIL, pill, is not a cure for every ill. So, no, you've raised a very good question, and the Supreme Court has actually, I think, issued notice to the central government in this matter. If there are so many billions stacked, someone has said if the interest from the billions which are stacked, I think it was mentioned yesterday in the lecture, someone read from a paper, the interest on that would be more than sufficient for 2 budgets. But that may be an exaggeration, but the judiciary is not complete. The judiciary must act within the parameters of the law and the constitutional limits.
Thank you, sir.
I request Justice M. Rama Joyce to deliver the presidential address.
Honorable Justice Ravindran, Justice Malimat, Justice Rajendra Babu, Justice Ravi Malimat, and other dignitaries. You have listened to a very scintillating address by former Attorney General of India, Soli J Sorabjee. He is known throughout the country as one of the most eminent lawyers of our country, and argued large number of cases and has been responsible for the molding of our constitution. When such a person has addressed on an important subject, the practice among the judges is, it is sufficient if I say I agree with him. Therefore, in the first instance, I agree with every one of the points which he has highlighted in his address. One point which he pointed out, that is about qualification for elected candidates. Even as early as when the constitution was drafted and voted out, then Rajendra Prasad had said that you have prescribed even qualification for even a second division clerk. Why not there should be no qualification for persons who are becoming legislators and ministers and president and vice president and all that. Therefore, it is a matter for consideration and what sort of qualification should be prescribed. Whether the election commission should prescribe a particular examination to be passed for being a voter, then what would happen to our adult franchise? This question also will arise. But anyway, it's a very important point which should be taken into consideration by the parliament as to whether it is necessary to prescribe a qualification for the voters and elected representatives. Then, as far as Article 21 is concerned, as the learned speaker has said, though its life and liberty has been expanded by the Supreme Court by way of interpretation, and it covers everything which is important for life and liberty. So even say, even in prisons, how a prisoner should be treated, and even police custody, how a person should be treated. All these have been laid down by Supreme Court. It is the right against hunger. All these points are covered by the various judgments of the Supreme Court. Another point he stressed was about lawyers being a service-oriented profession. So as early as in 1924, Mahatma Gandhi had cautioned lawyers, don't make your profession subservient to your purse. Lawyer's profession is a duty-based, service-oriented profession. Here what we forgot was, while framing the constitution, one important aspect which was completely lost sight of by our founding fathers of the constitution is to make our society a duty-based society. You take from most ancient times, our country has been, a mark of distinction is ours is a duty-based society. In Vishnu Purana, there is Yatohi Karma Bhuresha Atonya Bhoga Bhumiya. It is said that this country is mainly essentially a duty-based society, whereas others are right-based. Mahatma Gandhi in his book, My Picture of Free India, that is not available in the market, I have got one copy. The first paragraph he says, India, I love India most, not just because it is my motherland, but because it has given the highest values of life for the whole world. And adds, India is a duty-based society as distinct from right-based societies. This was forgotten, but fortunately, during a wrong time, a right chapter was added to the constitution. Fundamental duties were added by 42nd Amendment during 1975. And according to me, one right that should be given to all individuals, that is what Leon Duguid, a professor of in Bordeaux University, says, the right that should be given is the right to perform his duty. Therefore, after incorporating the fundamental duties chapter, one right, every citizen has got the right to perform his fundamental duty. That should be, even now it should be understood like that after the introduction of the fundamental duties chapter. Then about the National Judicial Commission. See, even recently in Rajya Sabha, the question had come up regarding transparency among judges. I said transparency among judges will certainly be there provided there is transparency in appointment. You first make transparency in appointment, eschewing collateral consideration in making the appointment, you will get naturally the transparency among the judges. That has to be done. And another thing is about secularism. You see, many people say that our constitution is Western based and there is nothing of our culture and all that. It is not like that. I have studied the entire constitution and also our Rajadharma or the older constitution. Every one of the fundamental principles which are involved in our culture for last more than several centuries are incorporated in the constitution. For example, equality. Equality, our species is Yatha Sarvani Bhutani Dhara Dharayate Samam. This is our Rajadharma. Just as Mother Earth gives equal protection to all citizens, the state should give equal protection. That has been there. And secondly, another thing is Pashinda Naikama Pugavrataganaadisu Samrakshet Samayam Raja. Disbelievers in Veda should be given the same amount of protection as to be given to the believers in Veda. This is the extent of secularism which is in our blood. And respect for all religions. The question is, there is some people say, this our dharma or Hinduism is a most tolerant religion. I say no. Tolerance means you are a nuisance, still I tolerate. But we accept every religion. That is actually the widest acceptance for all the religions is our cultural value. And that is found in Article 25 of the Constitution. So Article 14, 15, 16, 25, 26 and all that, so all the important rights which were evolved in our culture, values, cultural values, are found incorporated in the Constitution. The difficulty is only in implementing. The problem is, while implementing the Constitution, we are not implementing it properly, and that has given rise to so many other problems. Having regard to the fact, the subject matter of today's lecture is review of the Constitution of India. I have also noted some of the points which I have already written in Golden Jubilee edition of the Parliament. The Secretary General in 1990 had written to me to write what are the provisions in the Constitution which requires to be improved, and therefore I wrote the article which has been printed. That volume I have given to Justice Putswamy. 2-3 points I will which requires review in order to make our democracy more effective. One is appointment of Prime Minister and Chief Minister. The question is, now the practice followed is, the President or the Governor appoints, and thereafter the matter goes to the legislature. In German Constitution it says, the legislature should elect the leader first, and the President and Governor will have no choice, they have to make the appointment. And for that purpose, the person who becomes the Chief Minister or Prime Minister must be a member elected to the Legislative Assembly or House of the People. You see, there is a very crucial article. Article 74 says the Governor shall appoint, President shall appoint the Prime Minister. But 75(3) says the Council of Ministers shall be responsible to the House of the People, not to the Parliament, Lok Sabha. Similarly, in Article 164(2) says, the Chief Minister and Council of Ministers shall be responsible to the Legislative Assembly, knowing full well there is a Legislative Council. Therefore, the stress is on Legislative Assembly and House of the People, and the person to be appointed as Prime Minister or Chief Minister, as the case may be, must be from among the elected candidate to elected to the Legislative Assembly or the House of the People, as the case may be. And the election must take first and appointment should take next. Now what has happened is, some person is appointed and there are instances where within 13 days or 15 days he can't prove the majority, and then the government is and that is not contemplated by the Constitution. That is one matter which requires to be attended to by the Parliament, so that there will be no temporary ad hoc Council of Ministers are appointed subject to approval by the Parliament. Once Governor or President appoint the Chief Minister or Prime Minister, he becomes punctuis officio. Whether he should continue or not must be tested in the legislature, and that is the principle laid down by the Supreme Court in Bommai's case. He can't be decided on the lawns of the Raj Bhavan or Rashtrapati Bhavan. This is another important. And the election. Recently I had the occasion, what is the reason for people not coming in larger percentage for voting? This is a very important question touching our democracy. Now what has happened is, there are elections there every year. This Maharashtra election, Haryana, Arunachal Pradesh, next year Uttar Pradesh, still next year Bihar, like this. All this happened after 1970. Therefore, in 1990 itself, I said Constitution should be amended and there shall be only one election for Lok Sabha and assemblies throughout the country, and there should be election holiday for the voters for 5 years. 5 years they should not be bothered. And you see, elections are held in December, January, or June and May, where there is hot wave or cold wave, and how much problem is caused for the voters and the leaders of political parties. Nobody is thinking about it. In fact, if our country's economy is adversely affected because of politics. If elections are there only once in 5 years, and Lok Sabha and Assembly elections are held together, we will be saving hundreds of crores of rupees. But it is not being done. And elections are held during extreme period. Therefore, one of the suggestions I have made, if it is published by the Parliament itself, there should be no election in between 5 years. If an assembly, normally no assembly should be dissolved, and even if it is dissolved, then for the rest of the period there should be no election. They should wait for the completion of 5 years. Otherwise, we can't hold elections once in 5 years. And secondly, the date of election, it should not be left to the whims and policy of the election commission or the executive government. In America, president's election date is fixed. Nobody can alter it. Here also, month, because ours is a very large democracy having thousands of constituencies and number of states, the election months must be fixed by the constitution, and there should be no authority either for the election commission or for any political party in power to change it. It must be February and March, when there is a salubrious climate throughout the year, and the dates election commission fix the date, but month cannot be altered. That is one of the point which requires reconsideration while reviewing the constitution. And prohibition to contest. See, if a same person can contest for Lok Sabha as well as Assembly, and Lok Sabha for 2 constituencies, and one he resigns after that. Who is going to pay for the expenditure for the constituency for which he has resigned? Therefore, for the sake of whims and fancies of an individual, state exchequer should not be adversely affected. There should be prohibition for contesting for more than one constituency. Either you contest for Assembly 1 or Lok Sabha, but can't for both, or even for Lok Sabha or Assembly you cannot contest more than one seat. Then about another problem which has been facing for last more than 15-20 years about women's reservation for women in the election. Now every political party has said there should be reservation for women. Now it is not being passed, they are not going back. The problem is this. Why it is not? I have talked to so many people. What is the real problem? Suppose you reserve 33% of the constituencies for women. 33% of men politicians go out of circulation. Suppose if you reserve for SC, ST, you will reserve in a constituency where scheduled caste, scheduled tribe population is there. For women, which constituency you are going to select? In every constituency, they are 50%. Therefore, the way in which the things are going, that is why on house top they say we are for 33%. But when you say, if your constituency is reserved for women, what are you going to do? That is why we are opposing. That is happening. Therefore, there was a Surya Foundation in Delhi, which takes up all these issues, and on that committee I was a member, and we have made a proposal. The proposal is increase the Lok Sabha and Legislative Assembly seat by 10%. Suppose 554 seats will be increased. Make all those 54 seats available to women only. And then the election, introduce indirect election. Under 171D, from assembly to council election takes place. Like that, these 54% seats reserved for women, let them be elected by the elected representatives. Suppose a particular party get 200 seats in parliament, they can get 20 women elected, and they will not be bound to any particular constituency. You can select any woman throughout the country who is competent to serve in the parliament. And this suggestion was made. I am glad to inform you, Shri Balanandan, who was a leader of the Communist Party in Parliament, has sent this proposal to Atal Bihari Vajpayee. This is the most reasonable way of accommodating women in the Parliament without affecting men. That has been made. But still, that matter is going on. Nachi Appan committee is there, and we have to do something. And another is, recently I have sent an amendment to Article 37. Article 37 is in the Part 4 of the Constitution. It says, none of the directives in the Part 4 shall be enforceable by a court of law. The result is 3 articles important remain unimplemented. One is Uniform Civil Code, or forget Civil Code means it maintenance, adoption, civil property, at least regarding gender discrimination. Even the Clause 16 of the Universal Declaration of Human Rights says there shall be no discrimination between man and woman in the matter of marriage and divorce. Now, Article 44 says so. Article 48 says there shall be total ban on cow slaughter. And most important is Article 47, there shall be total ban on manufacture and sale of liquor. These 3 articles are not implemented. Why? You can just understand. The political reason and who will supply money for the elections. Therefore, my suggestion is Article 37 should be amended and say, other than Article 44, 47 and 48, these articles shall be enforceable by a court of law. The other article, general directives, but these are the specific directives which have not been implemented, they will never implement it because there is a electoral consideration in not doing so. And regarding judiciary also, certain curious things are going on right from the beginning of the Constitution. One such thing is an appeal from a single judge to 2 judges. You see, single judge delivers a judgment. Is it not a High Court judgment? It is a High Court judgment. But some practice from the British times, letters patent appeal has come and they are continuing. 2 judges hear the appeal presented by, against the judgment of a single judge. Where is the provision in the Constitution for appeal from High Court to High Court? Whether single judge delivers, 2 judges deliver, 3 judges deliver, or 5 judges, it is a High Court judgment, and appeal under the Constitution lies only to the Supreme Court. But this is going on. This also I have specifically written in the article, you please make an amendment to the Constitution, provide an appellate court in place of division bench, and then restrict the appeal to the Supreme Court to 2 matters, interpretation of Constitution and interpretation of central law. If you do that, until you do that, if you have this 136, it is impossible to, there will be lakhs and lakhs of cases, because the human nature is such, there is Supreme Court, let me try. And we know what percentage of cases are dismissed at the stage of admission stage. If statistics taken, general impression is about 80-85 cases are not admitted. Still, man says, so let me try. And they spent thousands and lakhs of rupees to go in specially, and this has not been attended to. Recently, Justice Lakshmanan has said there should be 4 benches of the Supreme Court. Then I said, I quoted Justice Thomas has written a beautiful judgment. He said, High Court means there must be Chief Justice, and Supreme Court means there must be Chief Justice, Attorney General. High Court, Chief Justice and Advocate General. And if you make benches, Chief Justice can't be there, Advocate General cannot be there. Therefore, Thomas said these benches should not be there. Therefore, I wrote to Lakshmanan, please consider if you have 4 appellate judges, appellate court, regional court, which should become final as far as civil and criminal matters are concerned, leave constitutional matters and interpretation of Constitution only to the Supreme Court. And that will solve the problem. And regarding appointment of judges, as I said, the National Judicial Council or whatever it is should be done. And regarding subordinate courts, in some cases the High Court does it, in some cases it is done by the Executive or Public Service Commission. In Karnataka, for instance, it has been entrusted to a committee of judges of the High Court. And when Justice Malimat went to Kerala, he also followed that and made it in Kerala also. The committee of judges of the High Court will make the selection, not Public Service Commission. Like that, this streamlining the appointment both at the subordinate court level and the High Court level is very essential. And there is one more suggestion which I had made is, one unanimous judgment or one majority judgment whenever bench consists of 3 or more judges. You see, what is happening is, Keshavananda Bharati, 13 judges, 6 minority judgments, out of 7, I think 1 or 2, there are 4 or 5 judgments. Justice Hegde and another gave 1 judgment. And in the High Court or even the Supreme Court, while arguing, lawyers will say, Justice Hegde has said so, Sikri has said so. You have to make a chart and each judge. Therefore, you write only one judgment. Majority. Dissenting should be there because the law has to grow. So whoever dissents, suppose there are 7 judges bench. If 4 agree, let there be one judgment on behalf of 4. Then there will be a lot of confusion will be avoided, and what the law under 141 is very clear to the people, but it is going on. Therefore, this should be done by convention, but it is not being done by convention. Therefore, Article 145 has to be amended and said there shall be only one judgment. Either if it is unanimous, well and good. If it is not unanimous, at least majority of judgment, there should be one judgment. This is one of the improvement which is necessary in the High Court level. And there are other matters like whether judges should be made eligible for further appointment after retirement, and whether there should be a gap and all that. They are all small matters to which I am not making the reference. These are some of the important aspects. If Article 47 regarding this manufacture and consumption of liquor, Mahatma Gandhi had so long as this continues, you can't improve the use or the economic conditions of the poorer people. If you give money for construction of house or purchase of cattle or bullocks or whatever, the money goes to liquor only. And that the only way you have abolished untouchability by Article 17. Therefore, like 17A, you make it and abolish manufacture of and sale of liquor by the Constitution itself. Then the question of making the law by the legislature will never do it, because that is the very source of money. In Supreme Court, once a remark was made by a judge, that is in Karnataka, there are 2 lobbies are functioning. One is liquor lobby, another is a professional college lobby, like that. See, so long this liquor lobby is there, they will never allow this Article 47 to be implemented. Therefore, why not make it Article 17B and say this is abolished? Then there will be no question of any state making law. These are some of the points which occur to me, which I have written, put it in writing and published by the Parliament itself in its Golden Jubilee edition. Thank you for listening to me for the words which I have spoken. And I once again thank Soli Sorabjee for his scintillating address and giving correct guidance in the matter of implementation of the Constitution.
It has been refreshing to listen to the thoughts of 2 of the best legal intellects in our country. As Mr. Soli Sorabjee said, Constitution is not a mere statute, it is the lifeblood of the country. No constitution can be perfect, no constitution can be permanent. But he also added the caveat that the Constitution is a sacred document. Both Mr. Sorabjee and Justice Rama Joyce have emphasized the need to make some of the directive principles justiciable. Off and on there is discussion in public fora on revision of the Constitution. For instance, very recently as a couple of months ago, the words federal, federalism and federation were loosely bandied about. Now, uninformed leaders do not seem to understand even the basic difference between a classic federal setup and one that is not. India was not a case of sovereign states coming together to form a federation. We were one country, the Indian Union, dividing its vast territory into provinces, subsequently designated as states. It is unitary and federal. with an overarching bias towards unitarism, as reflected in the sweeping powers invested in the center under the principle of union supremacy. In fact, 3 former Chief Justices of the Supreme Court, hailing from different regions of the country, Meherchand Mahajan, S.R. Das, and Hidayatullah, they favored a very strong center. Hidayatullah had declared in a lecture, a unitary form of government at the center is essential to prevent the disintegration and balkanization of our country through regional pulls and pressures. It is sometimes said there is nothing wrong with the constitution or the political system, and the fault lies with the people who operate it. I am afraid this argument ignores some basic facts. The people operating the system today are largely the products of this system. Secondly, the system is for the people and not the other way around, and it has to be adjusted to the needs of the people. Thirdly, we cannot keep waiting for some unidentified flying objects to descend, and our people cannot be changed or others imported to work the excellent system. It's just not possible. And lastly, the system and its operators are responsible for the failure. Now, if our representative institutions are to be made impregnable, both the system and the character of those operating it would have to be considerably improved or reformed where needed. If this is not done soon, remedial measures are not taken urgently, and governance does not become citizen friendly, people may lose faith in democracy itself. For this most needed exercise, both the eminent speakers, who, as I said, are among the best legal intellects in our country, they have provided many pointers. I hope the people in power will listen to these highly worthwhile suggestions and pursue it, and and see that soon we will see some action in this direction. On behalf of Indian Liberal Group and the Gokhale Institute of Public Affairs, I express a hearty vote of thanks to Justice M. Rama Jois and to Mr. Soli Sorabjee. I request Justice Puttaswamy to honor the 2 speakers.